Good afternoon, everyone. It's evening now. Good evening, everyone. Good evening. Good evening. We about to get into something really, really, really important. So, I'm going to wait for some people to show up and then we're going to get right into this. Because this right here, this is big. And I think this is going to be very, very, very helpful to a number of people. So we going to definitely get into this. So let's give it a little moment. Let some people come in here. I will be saving this video and I will be loading it to YouTube as well. So this video will be available on my YouTube channel and it will be saved on Instagram for everybody to view, because this is really, really important and I think it's going to really help some people. So I'm going to try to give a little time. I got a lot to unpack here, and IG only lets you go live for about an hour. So in light of that, I can't give too much time, but I'm going to try to give us a little bit more time to let people kind of trickle in so we can go ahead and get started on this. I'm going to run through this as quickly as I can to cover all the points. Again, as I said, there's a lot to unpack here. So, all right, y'all. You know what? I'm going to just go ahead and go because of time constraints, and I don't know how long it's going to take me to get through this. So this is a hashtag Get Real Woke, hashtag for the free discussion on getting your money back from the Tulsa Real Estate Fund and Jay Morrison. That's what this discussion is about today. Now, I want to cover a couple of things first and put out a couple of things that I think are important to understand. All right, so check this out, right? Number one, what you have to understand about the Security and Exchange Commission is this. They are a regulatory oversight committee. And what that means is that their job is to regulate the entire securities market and industry within the United States. Now, with that in mind, what you have to also understand is that the Security and Exchange Commission is not only understaffed and overworked, but oftentimes what you find with the Security and Exchange Commission is that, some of the employees there are not trained very well, right? And that was the good example of that was shown with what happened with Bernie Madoff and how many audits and investigations he survived before he finally told on himself, right? But more than that, the SEC is segregated into divisions and departments. And what do I mean by that? So when a fund or a company or a security is registered, right, that goes through their registration division. And that is completely separate from their enforcement division, which is the one that handles investigations, civil suits, recommends criminal prosecution to the United States Department of Justice, etc., etc. So, when you walk into this situation, what you first have to understand is, yes, the Tulsa Real Estate Fund was investigated. But there are a few things and a few caveats that you kind of got to understand about this investigation, right? Number one is the fact that when Jay Morrison was investigated by the Security and Exchange Commission, or the Tulsa Real Estate Fund was investigated by the Security and Exchange Commission, what you have to understand is that at that time he had not really deployed much capital. So there really wasn't much to investigate. They were investigating more. Overall, they were investigating the documents that he had filed and making sure that the major points of those documents were accurate and valid, which they are. So he survived that SEC investigation because of those factors. Now, with that in mind, remember I told you that the enforcement division and the registration division are two separate departments. So there were a lot of assumptions made by the enforcement agency walking in, or the enforcement division of the SEC walking in. One of which was that baseline statements were vetted and checked. For example, his background, all of these things, because that was the job of the registration division. The registration division's job was to make sure that he wasn't a bad actor as defined by the Security and Exchange Commission. Unfortunately, because again, they're overstaffed and overworked and a lot of them are vastly undertrained, what happens is a lot of things slip through the cracks that probably shouldn't, right? Not only that, because his felonies were drug charges, right, and not securities violations, that was overlooked. Moreover, a lot of times federal agencies don't do things like check, civil court filings, civil judgments, things like that. Those things tend to get overlooked, for better or for worse. And that was exactly the situation that happened here with Jay Morrison. Because had the proper due diligence been done, Jay Morrison would not be qualified under the rules to really be operating a fund. And that is the first point. That there is the first point of attack when you start attacking this fund to get your money back. Because the fact of the matter is, this is going to have to be a legal situation. And it's not going to go criminal until you make a substantive case in the civil court. What you're looking to do at this point in time is all of the investors, or majority of the investors, need to get together and file a class action lawsuit in civil court and ask the judge to grant an injunction against the Tulsa Real Estate Fund, which would freeze the assets and prevent him from being able to take any more of the money out of the fund while this matter is litigated. And so where are the litigation points at this point? So number one, we'll start with the baseline document, which was his offering memorandum, right? In his offering memorandum, and I'll read it to you, it states Jay Morrison is the Chief Executive Officer and Chief Financial Officer of the Tulsa Real Estate Fund. Mr. Morrison is a successful real estate developer, celebrity, realtor, author, TV personality, entrepreneur, and social activist, blah, blah. For the past 4 years, Jay has worked as the CEO and founder of the Jay Morrison Academy, which we can skip all of that and get into the disclosures. Despite being a high school dropout and an at-risk youth and 3-time felon, Jay made a major life transformation for the better over a decade, and that not only made him a millionaire before the age of 30. Let's just stop right there and consider that, right? So Jay Morrison made a statement that said he was a millionaire before the age of 30. The veracity of that statement is questionable because Jay Morrison is 40 years old. That means that was 10 years ago. And we know that before Jay Morrison started the Jay Morrison Academy, which he started after 30, that he was living in a foreclosed house and he was dead broke. So what that statement is called, right? That is called a misrepresentation of the facts in furtherance, right? This is a misrepresentation of the facts in furtherance of the desire to induce people to invest. We know Jay Morrison was not a millionaire before the age of 30 if you were homeless and sleeping in a foreclosed property and all of these other things that have come to light. When you started the Jay Morrison Academy, you're 40 years old now. 30 was 10 years ago. You're saying before the age of 30. So that was over 10 years ago. There's nothing in your background, nothing in your track record, etc., to demonstrate the fact that you were a millionaire. Now, it would be very easy to discover this if the SEC had have done the proper due diligence and investigation and vetted the veracity of the statement. All they had to do was pull his tax returns. His tax returns would have told the story. Right? And once the tax returns would have been pulled, it would have been discovered that Jay Morrison, in fact, was not a millionaire before the age of 30, and that would have been a misrepresentation that would have barred him from registration. Right? Moreover, there are some omissions here. There are material fact omissions here. So here are the material fact omissions. When you look at this, right, and you really consider the statement that he made in his offering memorandum, he failed to make some key disclosures. And here are the key disclosures. He did not disclose the fact that at the point in time that he was registering this fund and issuing this offering memorandum, that he was in the process of a bankruptcy. He failed to disclose that. That is a material fact, a material statement that would have potentially swayed people from making investments in the fund. And because of that, and because it is a material statement, it must be disclosed in the offering memorandum per SEC rules and regulations. And because he failed to make that disclosure, right, at that point in time, these documents are not in accordance with SEC regulation. And because of that, a civil court of law would rule that every investor that invested in this fund under false pretenses and misrepresentations would have the right to get their money back, which is why you guys need to file a civil suit, right? Number one, and you need to ask the judge to grant you an injunction to stop this from continuing. Now, beyond that, there is another material fact that was omitted, which is, if you read the bankruptcy documents well, which I actually have, right? He is seeking to discharge a $200,000 judgment that was entered against him in a court of law, whereby he sold a property under fraudulent pretenses. The fact that that judgment was entered based on the assertions that were made in a court of law, that means that the assertions have been sustained by the court of law, and therefore they are accurate on their face. And he failed to disclose that he had a $200,000 judgment and what that $200,000 judgment was for. That is a material omission. And because of that material omission, had he made that full fair disclosure, it is very unlikely that the amount of people that invested in this real estate fund would have invested. It would have changed the outcome. And anything that can change the outcome of an investor decision that is adverse must be disclosed in the documents. It must be disclosed. Moreover, because of the fact that he had that judgment, SEC rules would have considered him a bad actor. And let's talk about what a bad actor is. So under the SEC rules, when you go to register a fund, whether it's a Reg D, Reg A, Tier 1, Tier 2, whatever you want to call it, you are still subject to what's called a bad actor disqualification. And what the bad actor disqualification says is the bad actor disqualification provision contained in Rule 262 of Regulation A, which is what he's registered under, disqualifies security offerings from reliance on Regulation A if the issuer or other relevant persons such as underwriters, placement agents, and the directors, officers, and significant shareholders of the issuer, collectively covered persons, have experienced a disqualifying event, such as being convicted of or subject to court or administrative sanctions for securities fraud or other violations of specific law. The reality of the situation here is, because he received a judgment for $200,000 and the basis of the assertions for the judgment being issued was fraud, he would have been qualified as a bad actor. And if the SEC had have done proper due diligence at the time of registration, he would not have been able to register this fund, period. So these issues are prevalent. and important issues that investors need to be raising in a civil court of law. Because once you raise these issues in a civil court of law, you get an injunction and a judgment is issued. Not only will they liquidate the fund, but now you have sufficient standing and the SEC has no choice but to get involved. And they will have to litigate. Now, beyond that, because there is more, right? So Reg A is actually, the Regulation A is actually a securities law, right? And so there is a long documentation, and that documentation is 454 pages, of which I am intimately familiar with. So I pulled the document, and just for the record, let me see something here. Just for the record, I have the document right here. It's 454 pages. Let me show you. Boom. Let me just scroll it a little bit. Pull up this, there it goes. 454 pages, right? Boom. Right? So I'm talking right now directly from the documents. I'm talking directly from the law to you, right? So now, when you are a Reg A fund, Tier 1 or Tier 2, there are some specific rules that you have to follow. One of which is this. Limit the amount of securities that an investor who is not an accredited investor under Rule 501A of Reg D can purchase in a Tier 2 offering to no more than 10% of the greater of annual income or net worth for natural persons. So that means that anyone in this fund that invested more than 10% of their annual income, he violated the law when he did that. If he accepted money from anyone and that money was more than 10% of their annual income, that is a violation of the regulation for which this fund is registered. And here's the interesting thing. It only takes one person to shut this fund down. One. If he did it one time, he's done. Because what the SEC tells fund managers, right? Investment bankers, fund managers, what we all know is this. The onus of doing due diligence and investors falls on us. We have to conduct KYC and AML. Know your client and anti-money laundering. So just because an investor fills out a form and checks a couple of boxes, if you did not perform sufficient due diligence, it is your fault as the fund manager. You have to conduct reasonable and adequate due diligence to ensure, especially when you're dealing with non-accredited investors, to ensure that the money you are taking on is in accordance with the security rules and regulations as written. Period. Now, let's take it a step further. The exciting thing is there are limits to what the Tulsa Real Estate Fund is allowed to invest in. And the reason why that is because under Reg A, which is the same document that I have up in front of me right now, Reg A requires specific security exclusions, specific things that Reg A funds cannot invest in. And one of those things exclude asset-backed securities, as defined in Regulation AB from the list of eligible securities. The Tulsa Real Estate Fund is not allowed to invest in and offer securities in asset-backed securities, period. What is an asset-backed security? I'm glad you asked. I actually have Regulation AB right here. So I'm going to read it to you. Regulation AB defines an asset-backed security. It says it just like this. Asset-backed security means a security that is primarily serviced by the cash flow of a discrete pool of receivables or other financial assets, either fixed or revolving, that by their terms convert into cash within a finite time period, plus any rights or other assets designed to assure the servicing of timely distributions of proceeds to the security holders. Now, a loan is an asset-backed security. The moment Jay Morrison started lending money, he violated Reg A, period. He cannot lend money. It is defined as an asset-backed security. Why? Because he is lending money. The money is secured against real estate. That piece of paper is a security, right? And at that point in time, that security's veracity or validness is based on underlying cash flow that will be generated and secured by real property or real estate. That is an asset-backed security by definition. He could try to make the argument, I didn't sell an asset-backed security. I sold member interest in a fund. However, the moment that the fund's proceeds were invested in loans, the investor's return was tied to the return of those loans. It was tied to the return of asset-backed securities, which made the investor's shares in asset-backed security, or what is better known as a collateralized mortgage obligation, or a collateralized, really it's not even a CMO, it's a collateralized debt obligation, because what you have is a security being secured by another security which is tied to a piece of real estate. And because that real estate is the loan on it is a debt, we consider those collateralized debt obligations on Wall Street. But anyway, that's a whole separate conversation. The net effect is he is violating Reg A right now. And there's no way that he can undo that, because he's already lent money. He's already secured it against real estate. So the fact of the matter is you can't go back. You've already done it. You've already violated Reg A. So now the question becomes, I'm sure you're going to ask, well, he's filed annual filings. He's done all of that. Why is it that the SEC hasn't stepped in and done anything about it? Remember what I told you. They regulate the entire securities industry in the United States. This is one filing in hundreds of thousands of millions of filings. Unless somebody is going to raise these complaints properly to the SEC, this will fly under the radar, because they already did an investigation. They already cleared him, so he's not on their radar anymore. So unless you raise these complaints and raise these issues properly, the SEC is unlikely going to catch on to this until long after all of this money has been blown and put in his pocket and all of that. We can stop this now. We can stop it now if the investors take proactive maneuvers to ensure that they take the proper steps that I'm telling you about right now and bring this into a civil court, get an injunction, right? And stop him from trading while this gets litigated. Once litigation begins, the SEC will begin another investigation. I guarantee it. They have no choice. Now, let's talk about something else, right? Where else has he potentially violated the law, right? Okay. Check this out. Now, Jay Morrison and the fund manager, Jay Morrison is an officer or director of the fund manager. The fund manager manages the funds on behalf of the issuer. Jay Morrison, as an officer or director, has the right to raise funds. He has the right to market funds, market, solicit, and raise capital for this fund. However, if he had third-party marketers in place to help him raise funds, he has violated the law. Check this out. What is a third-party marketer? A third-party marketer is someone who raised funds on behalf of the Tulsa Real Estate Fund. And that doesn't mean that you gave them your money to give to the Tulsa Real Estate Fund. If somebody else sent out an offering memorandum, if they sent out any marketing literature, if they did anything like that, right? Guess what? They have violated securities law, because the only people that can be third-party marketers and raise capital for registered security issues or security issues that are claiming an exemption under a specific security rule or regulation are broker dealers. That means that you have to be a broker dealer registered with FINRA, period. If you are not that, you cannot raise third-party funds. You cannot circulate offering memorandums on behalf of an issuer. You cannot circulate marketing material. You can't do anything like that. Now, here's the interesting thing, right? Some people may say, well, it was his employees that did it. I'm glad you raised that, because here we go, right? Let's talk about that. The primary requirements are that the associated person must not be subject to statutory disqualification, right? This is for third-party marketers. As defined in Section 3A 39(2), compensated in commission, and 3, at the time of his participation in associated persons of a broker or dealer. In addition to the 3 mandatory requirements, the associated person must satisfy one of the 4 criteria under 3A. The alternative set of requirements that may be most useful to fund managers are found in subclause A, which, in order to qualify, requires an associated person to have substantial other duties than marketing securities, 2, have not been associated with a broker-dealer in the prior 12 months, and 3, to not participate in securities offerings more than once every 12 months. Fund managers may qualify for this exemption, but a full-time employee in a marketing department offering securities on a continuous basis is unlikely to do so. So guess what? If he had employees at that fund that were sending out offering memorandums and marketing documentation to raise capital, and they did it more than once in 12 months, they are a third-party marketer. And if they were not broker-dealers, which I guarantee you they were not, he violated the law. Period. There's no way around it. It's a violation. And here's the exciting thing about that type of a violation. That type of a violation opens the door to what is called a rescission claim. Did you know that if you invest money into a fund via a third-party marketer, right, and that fund does not perform well and you lose money and it's some bullshit and it's mismanaged, right, you have the right to go into court, sue, and not only will you get all of your money back, but you will get interest on top. How about that? I'll read it to you. In this circumstance, many states uphold that an investor has the right to seek his/her money back plus interest if the person who solicited him/her was not properly registered and he/she has sustained a loss. Period. Period. It's called a rescission claim. That's what it's called. Moreover, let's take this a step further, right? See, we when you know the law and you know the rules behind this, it's different. So how about this? Hedge fund fraud and mismanagement. Just because you're not criminally committing fraud doesn't mean that you're not mismanaging the funds. Hedge funds are high-risk investment vehicles, and their failure may be more likely than with other investment vehicles. There are numerous ways that these funds become distressed, including cash flow problems following a period of poor returns, excessive leverage, and a lender making a margin call that compels the fund to liquefy assets at a steep discount. So here's the thing, right? When a fund manager mismanages funds, right, because they didn't have the sufficient track record to be able to manage properly and didn't put the proper risk management procedures in place, right, you have the right to sue them for violating their fiduciary obligation and responsibility to you. A fund manager has a responsibility to do everything within his power to protect investors from loss. He has the obligation to make full fair disclosure of everything that could be adverse to the fund, up to and including his background. So when a fund manager fails to do that, and you can demonstrate, and it's not hard to demonstrate in this situation, that his failures were due to mismanagement because he lacked the background and experience to sufficiently manage the fund, now you have a fiduciary violation, and now you have the opportunity to raise another point in your civil lawsuit. So, I wanted to, So I wanted to raise these points to you. Let me make sure I covered everything here. Yes, it did. So I just wanted to make sure that I covered all of these great, wonderful things with y'all, right? I wanted to explain to you how it is, because a lot of people are reading these offering memorandums, right? They're reading Jay Morrison and the Tulsa Real Estate Fund's offering circular, and based on how it's written, it's very crafty written. It seems like, it would be very difficult, if not impossible, for you to be able to get your money back, right? And I want you to know that just because an offering circular is written a certain way, just because it seems as though they're not criminally liable, criminal court and civil court are two totally different things. And there is always more than one way to skin a cat. There is always more than one way to skin a cat. I'm telling you. And I have just given you point by point ways that you can go into civil court on a class action, ask the judge for an injunction based on all of these points, and a judge will grant you an injunction. More than likely, you're going to get an injunction while they litigate, because there are clear violations of security law here. And if you go point by point by point for how I broke it down right now, and you raise these issues properly to the Security and Exchange Commission, they will open another investigation. But I recommend filing a civil suit first and asking the judge for an injunction to stop him from being able to move money. Once an injunction is issued, the court will likely appoint a receiver to hold the funds in the account. They will freeze the account to stop him from moving money any further while this is litigated. If you want to get your money back, if you want to stop the losses, if you want to stop the mismanagement of funds, if you want to stop the fiduciary violations, if you want to stop the double dipping, this is how you go about doing it. For some of you guys, you're saying, I only put in $500. This is too much of a headache. But if we don't stand for something, if you don't stand for something, you will fall for anything. When is it that we as a community are going to stand up and say enough is enough and stop letting people like this get away with this nonsense? It's not just about your $500. It's principle at this point. It is principle. It is principle. I'm telling you, this is how you go about dealing with this. Stand up and stop. And there are many other people invested, and a lot of people invested a lot more than $500. Some people tied up their whole life savings into this situation. When are we going to say enough is enough and stop this? So that's what I had to offer today. That's what I wanted to share with y'all. That's what I wanted to break down today. All the legal ways that you can go about getting your money back. Alright? So I hope this was helpful. You know what I mean? I hope y'all learned something. And more importantly, I hope you use this information to take action. And stop this foolery. Because it's foolery at this point. But anyway, y'all, like I always say, listen, like, subscribe, share, follow, tell anyone that you can that you think can benefit from this information right here, because the more people that receive this information, the more people that can benefit. Again, this is hashtag Get Real Woke, hashtag for the free. I hope y'all enjoyed it, and I'm out.